Hello and welcome to this webinar session put together by Business SA in relation to critical incident response. Critical incident response. The steps taken by you now and in response to a critical incident will help protect your business and your people financially, physically and also psychologically. A critical incident is any incident that could result in the following to your business and the people within your business: a fatality, a serious injury, the risk of either of those occurring, financial penalties and costs associated with an incident, the portrayal of your business and potential prosecution of the business and the individuals such as officers, managers and workers. Business SA is the voice of business in South Australia, and they assist various organisations of various sizes to manage people and tackle the issues faced in today's competitive business environment. Our highly skilled professionals provide hands-on assistance to identify workplace challenges and drive growth at every stage of the business life cycle. Our focus is clear: to lead business into the future. We help maximise the potential of your expertise, actively represent the needs of employers in a complex regulatory climate, and provide real business value. This webinar is designed to assist your business to manage risks associated with potential workplace critical incidents. The aims and objectives of the webinar is to provide an understanding of the obligations that you face in relation to a critical incident, the rights that you have in relation to the work health and safety legislation, techniques to assist with the response to a critical incident, outline the key factors to effectively manage the incident, how to mitigate potential penalties that could be faced by a business in relation to an incident, how Business SA can assist you to attempt to prevent critical incidents, and how we have the expertise to assist you to respond to a critical incident. The next couple of slides just go through a few definitions. SafeWork SA are known as the regulator. They enforce and administer the work health and safety legislation in South Australia. Other states have their own regulator, such as WorkCover New South Wales, who enforce New South Wales work health and safety legislation. The Act explains the duties of parties such as employers, officers and businesses, workers and other people related to a work site. It details the regulator's role and powers. It provides information and details the representation such as health and safety reps and committees, the requirements to notify the regulator of certain injuries, illnesses and incidents. The regulations, they specify the requirements of certain hazards within a workplace, such as duties in relation to machinery, which is known as plant, chemicals, asbestos, the work environment, workplace facilities and amenities, to name a few, and how you go about managing those things within your business. Mitigation is the act of making a condition or consequence less severe. The mitigation of a punishment, basically. It's presenting all the reasons such as the positives that were in place before an incident or the positive acts that you've put in place post-incident. Legal privilege is a privilege that you hold when talking with your legal advisor, such as a solicitor, barrister or attorney, and keeping that information secure unless you give permission for that information to be freed up. So if you were talking to your lawyer in relation to an incident, then that incident investigation that you conduct alongside your lawyer would be legal privilege, and any findings that you find would not be admissible to any other person unless you give permission. A prosecution is the institution and conduct of a legal proceeding. Prosecutions under Occupational Health, Safety and Welfare are detailed on the Safe Work SA website and are available to any searching party if a prosecution has been undertaken. Work health and safety prosecutions have not occurred yet in South Australia due to a statute of limitations that allows the regulator to have 2 years to lay a complaint. A second part webinar is going to explain an enforceable undertaking in a little bit more detail. But an enforceable undertaking is an option that is available to businesses instead of taking a prosecution proceeding on. As far as changes in legislation, in 2012 in South Australia, the Work Health and Safety Act and regulations were put together. There were some changes, and just a couple that are relevant to this webinar are under Occupational Health, Safety and Welfare. The notification to the regulator was required within 24 hours. That's actually changed now, and notification must be as soon as reasonably practicable, or immediately once the business is aware, and it must be in writing or by phone. WHS section 35 to 39 of the Act covers the requirements related to notification. Officers, previously in Occupational Health and Safety, a business could appoint a responsible officer. Now, under Work Health and Safety, all officers of a business have a due diligence duty in relation to Work Health and Safety. The next few slides cover a critical incident case study. The case study is taken from Safe Work SA's website and Industrial Court judgment from the Industrial Court's website. The incident that's portrayed in the case study basically is where some concrete stairs had been constructed in a building that was being constructed. The concrete stairs collapsed and fell and struck a worker. Fortunately, he was not clear and was not seriously injured. However, there was a second worker standing on a lower adjoining flight who was uninjured as well. The collapsed stairs estimated between 3 and 3.5 tonnes, so it was a very serious incident that could have resulted in severe injuries, if not fatality. Safe Work SA were notified about the incident and attended the site, and they conducted an investigation. In relation to matters that go to prosecution under Work Health and Safety, they are heard predominantly in the SA Industrial Court for most breaches of legislation. There are circumstances, though, where matters will be heard in the Magistrates Court, but we won't go into that today. As far as the regulator, the Safe Work SA have powers, and in their investigation they would have involved things such as interviewing workers and witnesses, compiling, taking and photographing evidence from the site, taking measurements, issuing of statutory notices, interviewing the business, interviewing officers of the business, interviewing any associated contractors and workers who are witness to the event or witness to the details leading up to and after the event. Basically, Safe Work SA, the regulator and their inspectors can do what is necessary to determine the cause of an accident and whether there are breaches. The inspectors have detailed powers that are provided to them as per the Work Health and Safety Act, Part 9, Sections 160 to 166 specifically. In relation to the failures in this case study, Following the investigation by SafeWork SA, the business was charged with a breach of Section 19 of the Occupational Health, Safety and Welfare Act. Basically, the business was charged with a failure to ensure the safety of an employee, so far as reasonably practicable, and a failure to provide an adequate system for inspection of critical stage of construction. The business decided to enter an early guilty plea, and the case was taken to the South Australian Industrial Court. The court heard that the stairs had not been structurally attached to the first floor slab because no steel reinforcing was laid to connect the staircase to the building. And once the formed up stairs and steel reinforcing had been covered by the poured concrete, there was no way of checking the structural integrity of the stairs. The business had subcontracted the building of the stairs and did not ensure that the staircase had been inspected prior to the concrete being poured. And they faced a maximum penalty of $300,000 under the Occupational Health, Safety and Welfare Act and regulations. Of course, under Work Health and Safety, those penalties have dramatically increased since 2012. The magistrate made determinations and determined clearly the risk of injury that was created by the hazard of the uninspected structure was that of a double fatality or worse. In saying that, had the building been completed without anyone determining the risks that those stairs could collapse, the users of those stairs could have been put at risk at any stage later on. Magistrate Lesky called the offence an extremely serious breach. They're very strong words, but that just goes to show that when a critical incident occurs and a business is prosecuted through the courts, it's freely available information to any business, and probably not a good thing that you would like to see your business guilty of and having those words associated with your business. In response to the offence, the business did quite a few good things in dealing with the issue. Doing this, of course, helps to present your business as a positive business, that you're willing to learn from your mistakes and make changes. This all helps to mitigate any penalties that you may face and bring down that maximum penalty from, in this case, $300,000 to a lower level. As far as the penalty decision, the magistrate came up with a penalty of $125,000 for the offence and allowed a reduction of 20%. If you plead guilty in the courts at a fairly early time, you are subject to a discount, and that's a good thing. The result was a $100,000 fine, but also some fees and legal costs and victims of crime levy that had to be paid by the business. Could more have been done in mitigating the penalties? I believe so, yes. Quick assistance by a skilled professional organisation to guide the business in responding to and managing the critical incident could assist to portray your business in all its good light. Guidance on the business's rights and assistance in dealing with the regulator, SafeWork SA in this case, may help in not providing information that may be critical where you have the rights not to provide that. So getting those rights in dealing with the regulator is very important. An in-depth review of all the safety systems before the incident would help to represent the positive systems that the business had already had in place and may contribute to a lessening of penalties. In relation to a critical incident, certainly there are direct costs that are obvious to a business such as medical expenses and the property damage. But there are a lot of indirect costs that businesses quite often don't think of when they're doing an investigation to determine the real costs of the business. things such as premiums being increased for insurances, the productivity loss through investigations and people standing around talking about an incident and dealing with the regulator and their directions and orders. Poor exposure through the media is a cost to a business that could be catastrophic, in the fact that if your business is looking for future contracts and things like that, it would be a mark against your name. Possible loss of future contracts, poor morale of workers and their families towards a business, happy worker, happy family, and the support that that family gives to the worker means that that worker is very productive for you. Legal costs and possible prosecution penalties also could be indirectly associated with an incident. As far as the Work Health and Safety Act, it sets out safety duties of different parties at a workplace. So a person conducting a business or undertaking, or an employer business, they have various duties associated with work health and safety, from their primary duty being Section 19 right through to duties of designers, duties of installers, manufacturers, suppliers, and so on. And they're covered through Section 22 to 26 of the Act. A person with management and control is the owner of a building or the owner of plant, and their details and duties are covered in Section 20 and 21 of the Act. Officers, their duties are as a due diligence to the business, and their duties are covered in Section 27 of the Act. And workers, their role and their duties are covered under Section 28. And other people, such as the general public, visitors to a work site, they have duties and they're covered under Section 29 of the Act. As far as the penalties are concerned, bearing in mind that case study, maximum $300,000 fine, when you have a look at the penalties now, they've been categorised into 1, 2 and 3. Category 1 is the most serious offence, and there has to be a level of recklessness by a business or a person in relation to these categories. As far as Category 1, the person would have to be put at serious risk of a fatality or serious injury with that recklessness for that to be proven. Category 2 would have to also have evidence to show that a person, a worker, has been put at risk of a serious injury or fatality, and that there be breaches of legislations associated with that. The Category 3 is a penalty that can be put in place where there is just a breach of legislation within the Act. So what are your obligations as a business, as a PCBU? You have to manage your business's risks. In Section 17 of the Act, it spells out that you must eliminate, or where not reasonably practicable to eliminate risks, that you have to minimise those risks. So doing things such as identifying your hazards and risks, assessing them and controlling them, and putting in a system to review those controls is very important to your business. There's duties to notify the regulator of a notifiable incident. The duty is covered under Section 38, but Section 35 to 37 of the Act details what is a notifiable incident. Things such as a fatality. If you have a fatality on your work site, that's an immediately notifiable incident that Safe Work SA must be told about as soon as reasonably practicable, that you've known about that incident. If one of your workers or someone else at your work site is taken to hospital and treated as an inpatient as a result of works on your work site, then that's also notifiable. But look at those sections because they'll help spell that out to you. You must ensure an incident scene is preserved for the regulator under Section 39. So once you've notified them, you must make sure that all the pieces of the evidence are secured. Of course, you need to look after the person and get them to hospital and do all those things and make the area safe for your people. But other than that, you are not allowed to move things within a scene. You must consult with workers and their representatives, and that's covered under Section 47 and Section 70. And consult with other duty holders, and that's covered in Section 46, and they're all musts. Regulation, Chapter 3, Part 1, they spell out the basic duties that you have to manage your risks: the duty to identify hazards, duty to manage risks to health and safety using the hierarchy of control measures, maintenance of control measures and review of control measures, and they're very important to refer to when you're managing your risks. As far as the obligations of an officer is concerned, officers have a due diligence duty to the business. They must ensure systems are in place for your business to manage their risks, must ensure resources are available to manage your risks, ensure the business develops appropriate policies and procedures in relation to work health and safety, such as an incident policy and procedure, so your people can investigate incidents and deal with them and make sure that they don't occur again. Have an understanding of the operations of the business and its hazards and risks, and must ensure that notifiable incidents are reported to the regulator. As far as the notification requirements, PCBU must ensure that the regulator is notified immediately after becoming aware that a notifiable incident has taken place arising out of the conduct of the business or undertaking. Notification must be either in writing or telephone. You must provide details of the incident that are requested by the regulator. Must provide details in writing within 24 hours if the regulator requests that those details are in writing. And you must keep a record of the incident notification for 5 years from the notification date. There are some penalties related to notifications, remembering these are maximum penalties. So if you didn't report an incident that was determined as notifiable, there could be a penalty to an individual, such as an officer, for making sure that doesn't occur, and or the business as well. And they're quite significant penalties there. And if the scene of an incident wasn't preserved, there's penalties there as well. As far as multiple duties are concerned, certainly a person can have more than one duty in relation to a workplace. Take, for example, a small corner deli, call it Joe's Deli for an example. Joe may be the owner of the business. He may have set up his business in his name, and he may also be a worker within the business. So he would hold 3 duties there: as the business, as the officer, and also as a worker. Those duties cannot be transferred to another person. Your role is your role, and you must fulfill that role, even if you have more than one role. If more than one person has a duty for the same matter, such as maybe your business engages a contractor on site, you may share those duties, and where you share those duties, each person retains responsibility and must discharge their duty with regard to the capacity they have to influence and control the matter. So it's really important that you consult with each other over those sorts of shared duties that you may have when you've got contractors and labour hire people on your site. So if an incident occurs at a work site involving multiple businesses, each business must notify the regulator as per Section 38 to cover off your requirements, so there can't be any comeback from the regulator in relation to that. So if a contractor's worker falls from a roof on your site that you're having built, and lands and breaks their ankles, taken to hospital as an inpatient, it would be beneficial for both businesses to notify the regulator, the one who is in control of the site, being yourself, but also the contractor having their worker injured on your site. As far as the regulator is concerned, Safe Work SA, they have inspectors that go out to work sites. They enforce work health and safety legislation, investigate notifiable incidents. They issue directions such as improvement and prohibition notices. They produce briefs of evidence in relation to their investigations, detailing any breaches of legislation that they've found. They instruct Crown solicitors to issue complaints to a business or an individual that they perceive to breach legislation. The regulator and their inspectors have powers on entry. They may enter at any time a workplace that is, or that the inspector reasonably suspects is, a workplace, with or without the consent of whoever is in control of that workplace. They can inspect, examine, make inquiries at the workplace. They can basically do anything at a workplace that they feel is necessary to conduct their investigations. Things such as measurements, testing, sketching, recording, taking photographs, video, checking your CCTV footage, taking analysis and samples, all those sorts of things can occur at your work sites. They do have a statute of limitations. When you have an incident occurring at your work site and you notify them, if there were breaches found, they have 2 years from the date that they've been alerted to the incident to have those complaints laid against whoever the person is that has breached the legislation, whether it's the officer or the business itself or a worker within the business. So there are statute of limitations detailed on this slide. One of the rights that you have as an individual is protection against self-incriminating yourself. But this only applies to an individual, such as an officer, worker, or another person. A business doesn't have that right because a business is not an individual. An individual is excused from answering a question or providing information or a document to the regulator if they believe that may find them guilty. As an individual, such as a worker or officer, if an inspector suspects that you're guilty of an offence, they must provide you with rights such as you are not obliged to say anything or do anything unless you wish to do so. But whatever you say or do may be used in evidence. Do you understand? And it's a question commonly known as a Miranda right. If you are being interviewed, it would pay not to answer if the inspector has actually put that right to you, and gather a level of legal professional advice such as contacting Business SA. If you believe you are guilty of an offence as an individual, then you have the right not to provide a document that would incriminate you or answer a question that would incriminate you. But the same thing again, get that legal advice. A question like, were you aware that the machine did not contain the guard put to an officer of the business would possibly incriminate that officer if they answered yes. It is their right to say no, I do not wish to answer that question until I have legal advice. As far as incident investigation, when you conduct an investigation, you've got to ask yourself a few questions. What do you want to achieve from the investigation? Basically, do you want to make sure that this doesn't happen again? Do you want to have learnings from it that you can put across your business throughout Australia and maybe the world if you're an international business? How are you going to go about the investigation? How do you monitor the outcomes from that investigation to ensure that things are put in place and followed through? And what are your legal rights to the investigation findings and the outcomes? What do you want to achieve? Obviously, you don't want a reoccurrence of an incident within your business. You want to make sure that the controls that you put in place actually manage that risk down to the lowest reasonably possible outcome. Factual information that can detail the systematic failures that have occurred. You want to find out what they are so you can manage it really well from there. You want to ensure that you have a level of protection for the business and the individuals to ensure that there aren't undue stresses and potential penalties that could incur. So how do you go about it? Simple things such as writing down what you wish to achieve at an early stage, ensuring that you notify and preserve a scene if it's required, using your policies and procedures to guide your investigation, having an investigation procedure so it spells out to your people how to go about it would be a really productive thing to do. Detail the people involved in the incident, ensuring that you've written down who they are, what their role is in relation to the incident. They may have been a forklift driver that wasn't there on the day, but they may have driven the forklift that was involved in the incident the day before, and they may have critical information to say, well, actually the forklift brakes weren't working very well the day before. And that could piece together some factual evidence to show this was leading up to occur. And you could actually go, well, we need to have a better system of inspecting our forklifts and reporting when faults are found. You could refer to instructions, drawings, other applicable information, such as, you may have a procedure about the task that failed and led to an injury or an incident. Detail what is needed, who is to do it, and by when. So things happen. People are responsible for making things happen, and that there's time frames in place so that they happen in an effective manner. So how do you monitor the outcomes? I guess go back and refer to what it is that you wanted to achieve. Conduct a risk assessment, ensure that reasonable systems are in place, including ways to monitor the systems in the future. Have it so that it can be audited so that you can ensure that this reoccurrence won't happen. As far as legal privilege, your rights. You can conduct your investigation once you've talked to your legal professional, and the information that you derive from that investigation can be shared between you and your legal advisor and cannot be disclosed to SafeWork SA unless you give permission. But get that advice from your legal professional in relation to that. Have that built within your incident reporting system. All SafeWork SA directions, notices, inspectors' actions are certainly reviewable. Don't take that what the inspector is saying is gospel. Do some research, get some advice from people such as Business SA in looking at notices and interpreting what it is that the inspector is actually after and whether it's right that the inspector's asking for those things. In mitigating risks, things such as making sure that the workers that are involved in an incident and their families are looked after throughout the incident, visiting them, making sure that they're okay so that they're happy is a good way of mitigating some of the risks, because certainly an inspector will take a victim impact statement, and in that statement, if the victim in that case portrays your business as a good business, that you've looked after them, it's going to go well when the magistrate reads that. The knowledge gained from the incident is shared, so sharing knowledge with other industry groups is a good way to go about it, and showing that in the court of law is a good thing to say that, well, yes, we've had something go wrong, but we're making sure that it doesn't go wrong throughout other businesses. The community affected are looked after. So looking after your community is very good too. Showing remorse is very important. And presenting what were the things that you were doing well before, all those good systems that you had in place. And what are the things that you're doing well now, all the improvements that you've put in place. Portraying all those are very important to mitigate the risks to your business or to you as an individual. So what should you ask yourself right now? What systems do you have if a critical incident occurred today? Do you have systems to manage that well? Do you have skilled people that can investigate the incident for a positive outcome? What is the impact on productivity to have your staff dealing with the investigation, the outcomes, and Safe Work SA? Can you deal with Safe Work SA and their requirements comfortably? Do you understand the work health and safety legislation and its interpretations? Do you need assistance? Business SA offers support to any business in need of assistance in relation to work health and safety matters. They have skilled safety professionals, consultants, trainers with experience in managing critical incident responses. They can assist by managing the investigation and compiling your evidence for a positive outcome. Positive outcome could be putting all those things together to mitigate potential penalties. We can represent you with any dealings with Safe Work SA. We can interpret directions by Safe Work SA and how to comply with the direction or challenge an unfair direction that may have been put in place. We can piece together all the factors that will reduce any potential penalty to your business. So in review, hopefully I've provided an understanding of the obligations in relation to a critical incident and the response you should take. Detail your rights in relation to the work health and safety legislation. Provide techniques to assist with your response to critical incidents. Outline key factors to effectively manage the incident, and talked about the mitigation of potential penalties. Just in closing up, there's just an activity there with some questions just to start your thought process going forward and to see whether you've got some things in place within your business.